Good afternoon, lawyers. I believe we have a sizable number of you on call. And therefore we should start. This is the second module of family law practice. We have dealt with matters of children. In the first module, you dealt with marriage and divorce. In that first module, you were able to identify the various types of marriages recognized by the laws of Uganda, to determine which relationships amounted to valid marriages, those which were voidable or void, and the legal consequences. You were able to file, to draw a petition for divorce in your IA and also in workshop 2, and to advise the aggrieved party and the parties generally on their rights in respect of the property in dispute. In the first place, you answered the question whether or not it was matrimonial property and the rights of the parties in respect of that property. You also advised on matters of children. Because children are one of the natural consequences of marriage, we have had to deal with children. Our learning outcomes were that by today, you should know or have reminded yourselves of the rights of children, the remedies available for children in order to ensure their welfare. We were also particularly concerned with remedies that we can explore through alternative dispute resolution mechanisms, ADR. The courts of law have been emphasizing the need to pursue ADR remedies because they are fast and cheap, and the courts are also overwhelmed with the work before them. ADR will become so much more important to you in practice because last week the government of the Republic of Uganda passed policy on alternative dispute resolution mechanisms. So this was one of the critical learning outcomes this week. Not that we have not been exploring them, we have been, but I would like to let you know that in future, you are going to deal with ADR more than ever before. Lawyers did not want to embrace it because they think they do not earn costs, but here we are. The third learning outcome was for you to draw the relevant legal documents that you require in order to obtain remedies for child welfare. 4, we have introduced you to the skill of prosecuting applications of this nature before the appropriate forum that you identify in accordance with the facts you are dealing with and the relevant law applicable to those facts. Alongside all these learning outcomes is the need to observe ethical and professional standards. As you do your work, whether it is through litigation or only legal advisory work, or as you seek ADR remedies or out-of-court remedies, you have to work ethically and professionally so that you do not only create a name or reputation, but also you safeguard it. You should not be involved in things that will lead you to consequences of your practicing certificate being suspended or cancelled, or being struck off the roll of advocates. Apart from the embarrassment, if you care about that, that means that you will have no means of earning a livelihood. All right, I will now go through the tasks one by one briefly because your PAs have dealt with them satisfactorily. In workshop 1A, the objective of that task was to enable you explore one of the alternative dispute resolution mechanisms of seeking a remedy for a child in order to ensure their welfare, bearing in mind that the welfare of the child is the cardinal consideration in all matters of children. The brief facts were that the mother of this child works in Saudi Arabia, and while on holiday back at home, she learned that her daughter had been molested sexually by her biological father, and that her biological father had had a sexual relationship with their maid, which resulted into the birth of a child. Furthermore, the maid mistreats this child. The maternal grandmother of this child and the child have a great bond, and the child has told its mother that if she's not removed from this environment, she will commit suicide. So the issues are what remedies are available for Sarah Muddu in the circumstances, and what are the necessary legal documents. The other important fact is that she will be leaving Uganda for her work tomorrow. Well, by the time you did that task, she was supposed to leave the following day. It means, therefore, that she needed an urgent remedy. We wanted you to explore the remedy of biological parents of a child entering into an agreement in respect of the matter of custody of their child. That remedy is provided for under the Children Act. The parents simply enter into a valid contract, the subject matter of which is the child. The most important matter is custody of this child. The section requires that the agreement will not be valid unless it is witnessed by the probation and social welfare officer and that officer of the local council, area local council committee that you read about in the section. Apart from that, of course, being a contract, it must conform to all the features of a valid contract. As you noted, the courts will not enforce it if one of the parties is aggrieved that the contract was entered into under any of the factors that vitiate a contract. For example, duress or undue influence, or consent having obtained, lack of consent. So the further information you had to seek was the kind of information that would enable you to draft a valid and effective agreement that would ensure the welfare of this child. You had to bear in mind the requirements on this kind of contract under the relevant section of the Children Act and the ingredients of a valid contract as we know them under the Contracts Act and the common law. So definitely the facts point to the fact that the child has a great bond with its grandmother. So definitely that is the guardian. So you had to seek further information on name, address, the people who will be witnesses, maintenance of the child, who of the parents is going to pay for education of this child, medical care, clothing, in what form will child care support be given, the duration of the agreement. This father, who is the offending party in these facts, has a constitutional right to know and be known by this child. Therefore, you provide for the right of access to this child, the father's right of access, but you've got to ensure that he can only exercise that right reasonably. You provide for the hours of visit, which will not inconvenience the grandmother or the child, etc. So the remedy here was appointing a guardian by agreement. Most of you identified it. Some of you seemed not to know what further information to seek, but all that is a question of having appreciated the facts and the law. Once you know that this is a guardian, the remedy is appointing a guardian by agreement of the biological parents, and that this is a contract only, it is a contract for this purpose, then you know what further information to seek. I'm not going back to the sections because you ably gave them to us. So we should then proceed to the second task. In part B, Fred Bisoboka, the founder of Grace and Mercy Ministries, and also the proprietor of those schools in Bujiri district and that child home, has sodomized these boys. They are traumatized and they are in a terrible condition. So you are a legal officer working with the minister responsible for children, and he has asked you to advise him about the remedies available for these children. The objective of this particular task was to introduce you to Part 6 of the Children Act, yes, on care and protection of children. That part was introduced by the amendment to the Children Act, and it introduced a range of child protection remedies, including supervision, interim supervision, care order, interim care order, exclusion order, search and production order, contribution order. There are so many. Although this particular task does not cover the entire range of those protection orders, you were not supposed to limit yourself to the task. You are supposed to read about each and every protection order provided for in Part 6, to note the considerations or prerequisites upon which each of them can be granted, to note that they are granted by the Family and Children Court, and further, that they are sought by the Probation and Social Welfare Officer. When you read the law and you realize that advocates have no mandate to do this and that, you tend to ignore. But I can assure you that you are going to interface with these orders when you work as the magistrate presiding over the Family and Children Court. When you work in the NGOs you will join or establish to do child advocacy work, or when you work in legal advisory capacity in the various places you will work. Sometimes in private practice, somebody needs these kind of orders, but they don't know what to do, or they don't even know what the law provides for. So as advocates, you're going to help by being the liaison between the aggrieved person or whoever is responsible for this child and the probation and social welfare officer. And for that, for those kinds of services, you're entitled to charge a fee. But in our academic world at ldC, all these matters are examinable. And when you come before the oral examinations panels, we will expect you to know all these parts inside out. So if you sinned by limiting yourself to the task or not reading at all, please go back to Part 6 of the Act, look at each and every order there, note and learn the considerations, conditions upon which each is granted, and the nature of application. Rule 19 is very clear on how we seek each of these orders. So back to the task. Given the facts in Part B, the remedies were a care order, an interim care order. Of course, we need a supervision order because these children have been traumatized. They are psychologically and physically sick. They need to be counseled and guided so that they heal psychologically, mentally, and so that they can also leave the vice of sodomy. They never do it again. When they are placed under care, the probation and social welfare officer has a duty to do the supervision. And the supervision will include so much apart from counseling and guidance. You need to read the law. You will be able to appreciate it better. Apart from that, we need an exclusion order. These children, given the mental frame and physical frame in which they are, they do not want to see this so-called pastor again. So we need to seek an exclusion order as well. We need medical care. These children, when you are sodomized, I hope you can imagine what the children are going through. We need medical care for these children. Apart from this, you noted that a care order is limited in duration. It is not a lifetime or until the child gains majority age. So because it is limited in nature, you need to think about the long-term remedy of fostering these children and probably later on adoption. So we expected you to look at the foster care placement rules, which is a schedule to the Act. It is very detailed so that you could note what it means to foster a child, the duties of a foster parent to a foster child, how a child can be placed under fostering. In other words, what kind of application do you make? There's a form provided for in those rules. What conditions do you fulfill? They are all provided for in the rules on fostering. And we hope that when you are reading, you noted that the mandate to place a child under foster care is the role of the probation and social welfare officer. It is not the family and children court, but the district probation and social welfare officer. And you note that even when he has approved the application, he still has a duty to visit this home and keep on monitoring the status of the child. Okay, so if you sinned and did not look at fostering a child, please do so. Please read the rules. They are many, comprehensive, so that if you read yourself, you can learn. You don't need anyone to teach you about fostering. If there are no meanings of these words in the law, please refer to the dictionary of law first, so that you read the law with a clear understanding of the terms you are dealing with. Okay. So please read part 6 again and fostering in case you did not do it exhaustively. Masebizibu, part C, worked as a maid in Nixon Dombe's home. Nixon is one of the people you celebrate, you young people. He's a musician in Uganda. He made her pregnant and chased her out of his home. And she was a virgin. This was her first sexual encounter. She went back to her mother's home in Chanamkaka, Masaka. Her mother is unemployed. She's also unemployed. This child is not only an albino, but also a deaf mute. The child needs I'm sorry, I think the network had thrown me out. I am sorry, the network disturbed me and I was off. I hope you can hear me.
Yes, we can now hear you, Council.
All right, thank you. In part C of the, oh, thank you. In part C of the workshop, the issues are whether Massey can seek a declaration of parentage in respect of Nsinungi against Dombe. And if so, what is the appropriate forum, the procedure, and the necessary legal documents? A declaration, of course, when you are resolving issue number 1, you have to put it in context. She had her first sexual affair or encounter with Dombe. She conceived and gave birth to this child in Sinungi. Dombe denied paternity, and she now badly needs money to provide for the welfare of this child, including feeding, medical care, and the child needs regular medical care because of his condition. So against that background, since he denied paternity, the remedy available to her is to seek a declaration of paternity, the effect of which is that the person found to be the father of this child will have the obligations of a parent to this child. You took us through the sections, the appropriate sections. You took us through the burden of proof and the kind of proof we need, a DNA report, scientific proof. We know that when on the first hearing of this matter, as counsel for the applicant, you should be able to apply for an order that the respondent and the baby submit to DNA test so that you can obtain that scientific evidence, then the proceedings can go on. I'm sorry, the network keeps on disturbing me. I did not want to use my phone because I didn't think I would be audible. I normally don't get problems with my phone. I'm using a laptop. I have these problems. But you notice that apart from this, if he is declared a biological father, that is not enough. That is not all that she needs. She also needs maintenance. So the other issues are whether she can seek maintenance against Dombe for this child, what is the appropriate forum, procedure, and the necessary documents. Section 121, subsection 5 provides for the procedure. You took us through the remedy of maintenance and what it means. It provides for a complaint on oath. But you saw that contradiction under Rule 19, which provides for Form 1. Now, since Section 121, subsection 5 is the primary law and Rule 19 is subsidiary law, we will take the procedure provided for under primary law, that is complaint on oath under Section 121, subsection 5. So maintenance is also sought in the same way as a declaration of parentage. The parties are the same in both cases. The subject matter of this application is the child, the welfare of this child. So if you bring separate applications, it will not be strategic. It is better to bring an omnibus application to file a complaint on oath, by which you seek, one, a declaration that the respondent, Dombe, be declared the father of Nsinungi. Then you seek a further order that the respondent, having been declared the father of the child, provide maintenance for the child. It is the same application. We are seeking two orders in the same application. That is why we call it an omnibus application. Okay. We remember that you argued the welfare principle in all these cases. In part D of number 1, the facts are that you obtained the orders, as in C above, a declaration of parentage and an order directing him to provide maintenance for the child. Normally, the court will order him to deposit a certain amount of money in court monthly, or maybe on a certain bank account, whatever. So you are supposed to work on the premise that the court found him on the basis of evidence. The court made a finding that he's the biological father. Sorry, this child has sores on the right part of his body because nobody changes him as often as is ideal. Nobody changes his clothings or beddings as is ideal. He's fed once a day. Father is not interested in him, stepmother. So he's tortured, and he needs urgent, critical medical care, feeding, and attention. The other fact is that his mother loves him in spite of what he is, and so does his grandmother. And his mother has told you that she would like to live with her child. So the issues are whether Mase can apply for an order of custody in respect of Nsinungi, and if so, what is the appropriate forum, the procedure, and the necessary legal documents. The other issues are whether Mase can apply for an order of interim custody in respect of Nsinungi, and if so, what is the appropriate forum, procedure, and the necessary legal documents. Some of you may have raised issues in a lazy manner. What remedies are available for Mase? Appropriate forum, procedure, and documents. If you are not a smart student who reads very well, you will forget some of the issues and the resolutions. Some of you may have raised the issue, what remedies are available for Mase in the long term, what remedies are available for Mase in the interim. We look at each and every issue. We look at every word you write in your IAs. So anyway, I hope you have noted the issues. I hope you noted from the facts that we need a critically urgent remedy. That is why we are looking at the interim, because this child is suffering as he is. Then we are also looking at the long term. We need to get this child out of that situation as soon as possible, even if it means in a matter of hours or minutes or a day. Okay, so the first issue, whether Mase can apply for an order of custody in respect of Nsinungi. You took us through section 116 of the Children Act on custody, what it means, physical control of the child, and what it entails. You took us through the welfare principle, and you looked at it from the locus classicus like Law and Board, like Allen, like our Nakagwa, Dominico Chigundo against Nakagwa. You gave us that holistic meaning and you applied it to the facts, what the child is going through and what her mother is ready to do for her child. And you concluded that indeed she can apply for the order of custody so that she has physical control of this child in order to ensure welfare, because she's willing to look after her child. Forum, you told us the Family and Children Court. Some of you are not naming the court, but the law tells you where you should apply. The procedure, you took us to Rule 19, Sub-Rule 1J, Form 1, which is in the schedule to the Act. That application is supported by affidavit as the rule requires. We looked at your documents. Well, I did. On my part, I always do. I wanted to see your grounds and how you arrange them. I wanted to see among your grounds, I am the biological mother, the respondent is the biological father, the conditions the child is going through. Then we also wanted to see the ground on this application is brought in the best interest of the child. We wanted to see at least about 7 grounds. Then in your affidavit, you attach pieces of documentary evidence. Okay. The other issues are whether she can apply for an order of interim custody in respect of Nsinungi, what is the appropriate forum, the procedure, and the necessary legal documents. You took us through section 117 on the order, on the remedy of interim custody. This is a remedy that you will seek so that the child can be removed from this situation as you wait for the main application for custody to be heard and determined by court. Because in real life, an application may pend before court for months, for years. So this child needs urgent and also regular medical care, cries all day. Are you going to let this child cry? The sores grow bigger, the hunger, the malnutrition, the lack of medicine for years until the magistrate hears this matter? No. You are going to seek an urgent remedy in the interim, being an order of interim custody pursuant to section 117 of the Act. Forum and procedure. Forum is the Family and Children Court where you filed the main application for the order of custody of this child. Procedure. Section 117 does not provide for the procedure. Therefore, we invoke Section 98 of the Civil Procedure Act on inherent powers of court for the ends of justice and Order 52, Rules 1 and 3. Therefore, we will file this application by way of notes of motion under sections 117 of the Children Act, section 98 of the Civil Procedure Act, and Order 52, Rules 1 and 3. Take notice that, this application, this date for the orders that 1, the applicant be granted an order, the applicant be granted custody of the child of Nsinungi, a child aged that, pending the hearing and determination of family cause number this, which is pending before this honorable court. That is the order we expected to see in your notes of motion. The applicant be granted custody of Nsinungi, a child aged this, pending the hearing and determination of the main application for custody, which is pending before this honorable court. Then the grounds, the child is in the custody of the applicant is the biological mother. The child is in custody of the respondent. The child is sick and critically needs urgent medical care, but the respondent does not provide at all for the medical care of this child. The child requires good diet, but the child is not fed and is malnourished. Child has sores on its wound and so many. Then we expect to see that critical ground. If this application is not granted, the welfare of the child will be prejudiced. This application is brought in the best interest of Nsinungi, a child aged this. In your affidavit, we expect you to verify all those grounds and to attach documentary proof. Now, the title in this notes of motion, we expected to see something important. The Republic of Uganda in the matter of the Family and Children Court at this place. Miscellaneous application number 1 arising out of family cause number this of 2025. Not miscellaneous cause because it is not an independent suit. It arises out of a main application. So you should have named it miscellaneous application number this arising out of family cause number this. Then your parties. Notes of motion under that, we expect to see enabling law. You have a habit of citing so many laws which are superfluous. Section 117 of the Children Act, Section 98 of the CPA, Order 52, Rules 1 and 2, and you close brackets. Lawyers, you must have noted that in the part where we sought a declaration of parentage, we didn't seek an interim order of maintenance. We could not do so because this man had not yet been found. As a matter of fact, the father. So we could not seek an order of interim maintenance, but we sought maintenance because when the court makes a finding as a matter of evidence that he is the father, naturally, the obligation to look after the child should attach. So we could safely, as a matter of law, combine those two remedies in that application, but not one on interim maintenance. At that point in time, he was not yet the father and the court had not found him. But you realize that after the finding had been made, we are now applying for custody and maintenance. We can safely apply for an interim order of custody. We can also safely apply for an interim order of maintenance. And we can combine the interim order of maintenance in the application for the interim custody. Because you know she's unemployed, her grandmother who would help out, although she has no legal duty to do so, is also unemployed. So seeking the order of interim custody alone will not save the situation. Yes, she'll be able to give the child love, attention, and due care, but she needs money for maintenance of this child. So in this application, you can also seek an interim order of maintenance because he has already been declared to be the father of the child. Part E. In Part E, lawyers, you are supposed to gather the material facts by looking at that paragraph together with the court order labeled AA. In the court order labeled AA together with the brief little facts here, the Family and Children Court at Mukono, in Mukono Family and Children Cause number 12 of 2024, the magistrate granted the custody of this child to the biological mother and also ordered the father to pay maintenance, 3 million shillings. The further facts are that this mother goes out at night because she's a common prostitute and leaves the child under the care of a maid who is only 10 years old. The maid also spends the night dancing away in nightclubs. Whereas this order was issued on 8th December 2024, I hope there's no mistake there. Whereas this order was issued over a year ago, this child is not schooling. The father is aggrieved. So he says he's married and his wife is ready and willing to receive and raise this child. So the issues are whether the biological father of this child, the name you're supposed to pick from the order, can apply for variation of this court order. And if so, what is the appropriate forum, the procedure, and the necessary legal documents? The objective of this task was to introduce you to the remedy of seeking variation of a court order of the Family and Children Court if variation will ensure the welfare of the child. From the facts we have seen, the child does not go to school, whereas father dutifully pays maintenance as court directed. Mother is a common prostitute. She can never be a good example to this child because the welfare of a child is defined in a very wide sense to include the moral welfare of a child. The maid either cannot provide this child who is in a formative years an example. So the welfare principle dictates that this court order be varied or changed so that the welfare of this child can be ensured. You took us to the section on variation of maintenance orders, but that section does not provide for procedure. So we will invoke section 98 of the Civil Procedure Act on the inherent powers of court to make such orders as the justice of a given case require. The justice here requires that in order to ensure the welfare of this child, this order should be changed. So the application will be brought by way of notes of motion pursuant to that section. It will take me time to find the section, but I know you're looking at your act. It is section 123 of the Children Act, section 98 and order 52, rules 1 and 3. The title, the Republic of Uganda, miscellaneous application number that, arising out of Family, Children and Family Cause number 12 of 2024. The Republic of Uganda, in the Family and Children Court at Mukono, miscellaneous application number 1 of 2025, arising out of Mukono Family and Children Cause number 12 of 2024. The order, I'm not repeating the rest of that part, where the applicant seeks an order that the court order dated 8th December 2024, I think there was a little mistake there, be varied in the following terms. A, that custody of Tendo, a child aged this, that the order by which this honorable court gave custody of Tendo, a child aged this, to the respondent be set aside. B, that custody of Tendo, a child aged this, be granted to the applicant, biological father. C, that the order by which this honorable court directed the applicant to pay maintenance in the sum of 3 million shillings to the respondent be set aside. So when you seek variation of this order, you simply do not write for orders that the order be varied. You must show court the terms in which you desire the court order to be varied. Then in your affidavit in support, you use the facts given, how they prejudice the welfare of this child, and how varying the court order, as we have seen, will ensure the welfare of this child. And you attach documentary proof if you have it. If the facts are facts, you've got to think and to be ingenious and to attach facts, documentary evidence. All right, then we'll proceed to workshop 2. Workshop 2 was dedicated to adoption at the domestic level, international adoption, inter-country adoption, guardianship, all the forms of guardianship orders, and definitely to further your learning, your research and inquiry into fostering children. Okay. Part A, the Williams. You interviewed Lisa Williams, a nurse. Is she a gynecologist who has been working for Chitovu Hospital and whose husband is employed by an NGO, Hope for Every Child? The sum total of this brief is that she would like to adopt a child who is a Ugandan, 2-year-old, who was abandoned in Chitovu Hospital. We know the rest of the facts, but the other important fact is that the district probation and social welfare officer allowed her to foster this child only 6 months ago. And the other important fact is that the Williams, Lisa and her husband, are due to return in September 2025. Issues: whether the Williams qualify to adopt this child. Now, our client is Lisa. She's the one we interviewed. This statement is a statement of her interview. So the issues are whether Lisa Williams qualifies to adopt this child, and what steps should she take in order to adopt the child? What is the appropriate forum, the procedure, and the necessary documents? And what further information do we require from her in order to effectively represent her? The other task is that if we successfully represent her and the ruling is given in her favor, we should proceed to extract the court order from the ruling. You looked at the sections. Firstly, the meaning of adoption and the legal effect of adopting a child. You gave us the case law. Who can be adopted? A child under 18 need not be a Ugandan. You distinguished between adoption on the domestic plane and inter-country adoption. And of course, the facts relate to inter-country adoption. So you looked at the prerequisites for adoption, including the legal requirement that the intending adoptive parent or parents should have lived in Uganda for at least a year, the prerequisite on residence in our jurisdiction, the prerequisite on having fostered the child under the supervision of a probation and social welfare officer for at least 12 months, and so many others. And you also read the provision that the welfare principle notwithstanding, adoption will be a last resort remedy where all alternative care remedies have been exhausted and none can be found in order to ensure the welfare of this child. When you read case law and when you read the circular, I think it is, we gave it to you on the reading list. It is also available on the internet. The High Court issued that administrative direction requiring that adoption matters can only be heard by the family court at Kampala and no other circuit. I hope you looked at the date of that circular. The other prerequisite, which is not provided for in the Children Act, is that you require a report of the alternative care panel. That panel is under the Ministry of Gender, Labour and Social Affairs. Without that report, your application will not succeed. I hope you read the case I underlined I bolded. I hope you also read Libacov and several others. So when we look at our facts, of course, she does not qualify because she has not fostered the child for the minimum period required by the law. Secondly, we have no evidence that her husband has consented to adopting this child, and yet they are married, and the law requires that the spouse must consent. Now, the further facts are that this child was abandoned. Radio announcements were cast in the various media houses, TV, and nobody has claimed this child. The child is only 2 years old, and this couple is childless, and they are willing to adopt the child and provide for it. The law provides that the High Court can, under exceptional circumstances, waive some of those prerequisites. We hope that with your PS, you discussed the exceptional circumstances in this case, and they are there, the age of this child, no relative, nobody is willing to provide for her. These people are willing, but they are about to leave jurisdiction. You gave us some case law. There's case law like the matter of Nikundiwe. You also gave us other cases. Some of them were decided before the amendment that introduced these provisions, because then the requirement of residence was 2 years and the requirement of fostering was 2 years. But nevertheless, those cases still speak to waiver of exceptional circumstances. So although she does not qualify, we can still ask the High Court, apply for waiver of the prerequisite on fostering in the best interest of this child. So the appropriate forum, High Court Family Division, pursuant to that circular on your reading list, but we also need a report of the alternative care panel. I had wanted you to look at that case that is in bold on the reading list. It's beautiful. If you want to learn how to draft a petition for inter-country adoption, how to seek waivers from the High Court, or how to plead a waiver in such a matter, read that case. If one of the restrictions cannot be met, do not imagine that you can submit on waiver during submissions. You must have pleaded a waiver in your petition. And that case in bold beautifully illustrates how you plead. The entire petition, how you handle it when you are drafting. That matter was done by one of your teachers called Sechitoleko Chizito. It is a beautiful case. Please read it. So procedure is by way of a petition. You told us about the adoption rules supported by affidavit, but please look at that case. The judge reproduced the substance of the petition. It is a very, very beautiful guide for you on how to draw a petition for inter-country adoption and where you need to seek waivers, how you do it. I implore you to read that case. All right, we will not go through further information. That is theory. In part B, the facts are that Mariana Adieri Kajubiri, a Ugandan, has been looking after a child who was born by her deceased maid, and she would like to adopt this child. The only difference between parts A and B of workshop number 2 are that in B, you are treating adoption on the domestic plane at home in Uganda. That is the only difference. The other is the jurisdiction. In this matter, you will file your application, your petition, before the appropriate Chief Magistrate's Court and not the High Court. In part 2, part A, Gabriela Hick, looking after a child who was born by his workers, whose workers had faced animosity from their family, and their family didn't like them at all. He fears that looking after this child who is not his relative, that bad family, that cruel family, might bring him trouble one day or for the child. He's willing to continue providing for the needs of this child fully as a parent would, but his only concern is that this child should never inherit his property or have a share in his estate or money should he die. So when you look at the meaning of adoption and the facts in this case, definitely you guess that the appropriate remedy is guardianship. But the task is important. Advise Gabriela Kiki on the range of remedies available in this kind of situation and help him choose the ideal. So this objective was to enable you explore all the types of guardianship, the sections of the law that provide for them, case law, and by exclusion using your facts to discard what is not applicable and choose the ideal. So you looked at a guardianship by agreement, you looked at a testamentary guardian appointed under the will of testator, you looked at the parents being the natural guardians of their children, then you looked at a legal guardian appointed by order of court. And this particular guardian stands in loco parentis to the child and therefore has parental obligations to this child, custody, guiding this child morally, providing for its welfare, education, medical, shelter, clothing, etc. And that the relationship terminates when the child attains the age of majority. Well, legally, that is the position. The facts may always differ. You were supposed to look at those cases. There are 2 cases or 3 on your reading list, which were decided by Justice Mobiru, like Cliff Onen and 2 others. In those cases, Justice Mobiru explains who a guardian of this nature is, the one who stands in loco parentis to the child. He also explains the duties of a guardian to his ward. He also explains the considerations that a court of law takes into account in order to appoint a guardian of a child or to decline to appoint a person guardian of a child. You will find about 6 considerations. You need to know them because when you are drafting your application, you bear in mind not only the sections and prerequisites that legislation provides for, but also those conditions. Because when you come to the stage of making submissions, the submissions must be in tandem with what is in your petition. You will not make submissions that the applicant will not run into conflict of interest with the interests of the child if it is not in your application. You will not submit that he's the fit and proper person to be appointed guardian if it is not in your application and if there's no evidence of this. So I implore you to read those cases and to note those things, the meaning of a guardian, the nature of this relationship, the duties of a guardian to his ward, the considerations that court will take into account in order to appoint or not to appoint an applicant as guardian of this child. You need that package of legal principles. So we leave that because we have guided him that the ideal is for him to seek a court order appointing him as guardian of this child, and we have advised him on his duties to this child, the rights that the child as ward will have against Akiki as guardian. The forum, you told us it is the High Court, yes. Now, only the High Court can appoint guardians of children. In the past, it was open and it was abused by non-nationals. You also noted the prerequisites that the child must not have a relative or next of kin, or if she does, they are not willing to look after this child, and so many others. The procedure, you told us it is a petition, Form 1 in the Act. Thank you very much. We hope that you drew the court order. In part B of this workshop, Gabriela Kiki is the operator of Gabriela Child Daycare Center and Nursery School, which is registered on land known as Chadondo Block. And he's the father of 3 minor children, Gabriela Aboli, aged 10, Gideon, aged 5, and Maria, aged 3. Yes, this land is registered on Chadondo Block 185, plot 1120. He has this certificate of title. And this land is registered in their joint names, Gabriela Kiki and those 3 minor children. They are joint proprietors of this land. Akiki seeks to plan for the welfare of these children so that even if he should die, the welfare of his children should never be compromised. So he wishes to take a loan of 200 million shillings against the security of the title of this piece of land, which he jointly owns with the children, so that he can invest the loan money in completing this school, and furthermore in a guest house, so that the income from these investments can provide for the welfare of these children, even if he should die. So the land is owned jointly by Akiki and the children who are minors. Issues: whether Gabriel Akiki can apply for an order of legal guardianship, authorizing him to mortgage the said security to that bank, and if so, what is the appropriate forum, the procedure, and the necessary documents. Lawyers, the lazy students would raise an issue: what remedies are available for Akiki, what is the appropriate forum, the procedure, and the necessary legal documents. They would still get credit. Okay. From the facts we have identified, the co-owners of this land, Gabriela, Gideon, and Aboki, are minors. This land being jointly owned by their father and these children, they are jointly the only people who can enter into contracts of dealings or transactions in this land. However, the three co-owners are minors and have no capacity in law to contract. That used to be Section 11 of the Contracts Act. With the revision of the principal laws, I don't know, please kindly check. So they have no capacity to contract. It means that Akiki cannot enter into a mortgage contract with this bank and offer this land as security for the loan. So the remedy available for him, if you read common law, because this is not provided for under the Children Act, but at common law, the remedy available for him is to apply for an order of legal guardianship of these children, which authorizes him as legal guardian to mortgage this land to this bank. This particular order of guardianship must authorize the guardian so appointed to deal with the property of the minor in a particular and named way. In this case is to mortgage this land to this bank for 200 million shillings. Secondly, this application must be based on the welfare of these children. He must show that he seeks to mortgage this land for the best interest of these children, the co-owners. There are so many cases on this. I will not go through them, but the source of the law is common law. Now, lawyers, procedure, forum, documents. But let me first of all emphasize the difference between these two orders. The first order he sought in respect of the child of his deceased workers placed him in loco parentis. That kind of order does not permit you to deal with the property of the child. You will only exercise parental responsibility. For example, if these were the children of your brother or sister, if you want to deal with the property owned by a child, person under 18, you must seek an order of legal guardianship that authorizes you to deal with that property in the way the court order names. So the court order must be particular. So when you are drafting lawyers, pay attention to that. Otherwise, you will lose the application, you will not succeed. So, procedure. Lawyers, when you look at the meaning of guardianship under Section 2, It is limited to that person appointed by court to exercise parental responsibility over a child. It is silent on the power to deal with the property of a child. Furthermore, when you look at the petition, the statutory form of the application, the petition, when you read it word for word from the first to the last paragraph in that statutory form, that petition addresses the order to seek an order of legal guardianship that empowers you to be parent and to look after this child as parent, but not to deal with his property. I am aware that I listed cases seeking an order of legal guardianship to deal with the property of a child, in which cases lawyers proceeded by petition under the Act. I also listed cases in which lawyers proceeded by way of notice of motion. You notice that in both cases, the High Court granted this order. The High Court did not comment on procedure. It is because there's a gap in the law. The petition, which says guardianship should be sought by petition, only addresses the other kind of order. So the lawyers who proceeded by petition to seek legal guardianship order that enables you to deal in the property of a child modified that petition. That is why they were successful. The High Court did not reject. There are lawyers who argue that because there's a gap in the law, it does not provide for this kind of order. They proceed under Article 139, Section 14 of the Judicature Act, Section 98, and a notice of motion. And the High Court has not rejected their applications because the judges, I believe, are aware of the gap in the law. So if we set an IA or examination, I would expect the examiner to accept both procedures. As long as a student modifies a petition to suit the case of an application for an order appointing you guardian to deal with the property of a minor, and you see a case beautifully brought out by way of petition, the student should earn his good marks. If a student chooses a notice of motion and he beautifully justifies that notice of motion and understands the gap in the law, going by the limited definition of guardian and the petition being limited to that limited definition, and he ably tells you that I am relying on this procedure by notice of motion for these reasons, he should also get his good marks, as long as the order is brought out very well in both these documents. So lawyers, that is the procedure. The forum is the High Court. We have a gap in the law, but we can deal with it ably on the law we know. Okay, so we expected you to seek an order that whether you proceeded by way of notice of motion or petition, we expected you to seek an order that Gabriel Akiki, the applicant, Gabriel Akiki, be appointed the legal guardian of, then you name those children, of Gabriela Woli, a child aged 10, Gideon Arali, a child aged 5, and Maria Aboki, a child aged 3, and is hereby authorized to mortgage land known as Chadondo Block 185, Plot 1120, registered in the names Gabriela Kiki and Gabriela Woli, Gideon Arali, and Maria Aboki, minors until this year, to this bank for a loan of 200 million shillings. you realize that the order sought in this manner appoints him legal guardian for a specific purpose. Legal guardian and is hereby authorized to mortgage land described as this to this bank, which you name and the branch, for a loan of 200 million shillings. That is the order sought. If that order is not worded that way, the court will not grant your application. Or if it does somehow, you will have trouble in the land office. So, lawyers, your grounds. Applicant is the biological father of these children, is in custody, providing fully for these children, wishes in order to provide for the welfare of these children, education, etc., to invest in this manner so that another ground, the proceeds or income from these projects can be used to, Then lastly, we want to see that this application is brought in the best interest of these children. One of the grounds we want to see is that this application is supported by the report of the probation and social welfare officer as the law requires. Then in your affidavit, we are going to look at all this evidence of paternity, photographs of these projects and other evidence, and the report of the probation and social welfare officer, report of an expert, etc., etc. So when you have made your submissions beautifully, you have brought out the welfare principle, and the judge is satisfied that the father does not intend to exploit these children or prejudice them, but intends to invest for their welfare, the judge will deliver his ruling in favor of the applicant. You will attend court and record the substance of that ruling. Then someday you'll apply for a copy, but even before you get it, extract the order. This matter coming up for hearing this day or before this, and you beautifully type the order as the court has given it in the ruling. Then you go to the revenue and you pay for the order 6,000 shillings. There will be a bank charge, as you know, but the court fees for an order is, sorry, I have made a mistake, 9,000 shillings. Then you take it back to the court so that it can be signed and sealed. The judge will sign, it will be sealed. Then when it is sealed and signed, photocopy that court order, pay certification fees, get the receipt and go back to court. The registrar of the High Court will sign on it and write, I certify that this is a true copy of the order of court dated this, and stamp. After that, write a formal letter to the Registrar of Titles, Wakiso Ministry Zonal Office, applying for registration of this land in the name of the legal guardian, Gabriel Akiki. To that formal letter, attach a certified copy of the order. Then you pay registration fees, 10,000 shillings, no stamp duty. It is not a transaction. Registration fee, 10,000. Of course, you will take them together. If you know the law, you will already have paid your fees. When they will be received, the Registrar of Titles will verify from the relevant court records, and if he is satisfied that the order is authentic, he will register this land in the name of the legal guardian. Cancel out the first entry by which you see the joint proprietorship, then register the land in the name Gabriel Akiki, legal guardian, of these 3 children. Now, Then you will pick the certificate, the duplicate certificate of title, and that is when Akiki can mortgage to the bank and enter into the mortgage contract as mortgagor. He will now have legal capacity to mortgage this land. All right, lawyers, I hope you see the difference between the two legal guardianship orders. I hope you see the practical importance of this latter order that authorizes the applicant to deal or transact in the land owned by a child or jointly owned by an adult and a child. We do not stop at the ruling or extracting the order. We must take those further steps in the land office so that the land registration is proprietorship changes to the legal guardian. I know you dealt with this with Miss Nyangoma in your week 1. So, lawyers, I will now look at your questions in the chat. Queen, Rwandan. Under our constitution, one of the indigenous tribes I read about is Rwandan. I have my reservations about that, but there we are. Do we register legal guardianship orders? I have told you how we deal with the order, dealing with the property of a child, how we deal with it. It is not registration of that order with URSB. The other one you will register with URSB and the Ministry of Gender. There's a child department under that ministry. Don't cram things. For guardianship, there are 3 procedures. Petition, not understand the facts and the law and be able to justify the procedure. Don't just cram. It is not submotion. You must understand the law that takes you to that procedure. And that is why what I started with, I started by explaining the gaps in the law. And I told you, if it is legal guardianship to deal with the property of a child, if you choose petition and modify it, you'll be right. If you choose not submotion and give us the reasons based on the lacuna in the law and correctly, you will get the credit. In law, we don't cram. We look at the facts, we look at the law, and we come up with positions based on the facts and the law. Someone is asking me Rule 19. When we talk about Rule 19, and I said, we are looking at the children, family, and court rules. Omnibus application. You're asking, the law provides for procedure for maintenance, procedure for declaration of parentage. Why do we proceed by omnibus application? I told you it is a matter of being strategic and practical, bearing in mind the welfare of the child. I started by going through the procedure governing each and identifying the documents. Then I went to the facts. The facts are that the applicants are the same. It is the same child. It is before the same court. The facts are the same. Is it practical to file separate applications, each of which is by way of complaint on oath, so that you wait for the magistrate to make a declaration of finding that he's the father, concluded, order issued, extracted, then you go back for the other application to be heard. Even if you filed them separately, the magistrate would consolidate them. So the practical realities and strategic planning for your client's case would require that you consolidate them into an application. That is why we call it omnibus. The law is the same. The commonality to this is the complaint on oath, maintenance, and declaration of parentage. The facts are the same, the parties are the same, the child is the same, and we are looking at the welfare of the child. So, in practice, as a matter of practical strategic thinking and planning, we will file an omnibus application. If you file them separately, you will be consuming a lot of time in your examination, but your teachers will give you the credit. I understand you are straight from university, but when you go for clerkship, or later on as you progress in the course of the academic year, some of these things will be making a better sense by and large. The application for custody is brought by way of Form 1, supported by affidavit. The application for maintenance is brought by complaint on oath. Now, this court, because it is supposed to ensure the welfare of the child, does not insist on strict compliance, so that you file an application for custody first, an application for maintenance later on. You can combine them. So you have Form 1. You can also seek an order for maintenance in the same application and the court will not have it struck off, this court you have read is not required to insist on procedure or evidence, those rules strictly. It is all intended to ensure that these matters are heard expeditiously in order to ensure that the child is not prejudiced. So in real life, although maintenance is by way of complaint of oath, custody, you can always combine them if it is the same parties, just like we combined. But in the academic world, the students will normally draw separate applications because the applications are different for custody and for maintenance. You will get your credit. The student who argues in a very practical sense will also get his credit. So you don't have to worry, but at least know the nature of these applications, these different remedies, these applications and what you must prove. So I don't want to insist on practice. Draw your separate applications for custody, draw your separate applications for maintenance. But in this case, we needed an order of interim custody. So you would draw your Form 1 for custody, then your notice of motion for interim custody. You would draw your complaint on oath for maintenance, then your notice of motion for interim maintenance. That is perfectly all right. I will not insist on practice what we do for practical realities. For academic purposes, keep it that way. When you understand these things better, you will be able to believe that. But at least you have understood that custody, Form 1. When we need interim custody, there's no law, so you know why you would seek it by notice of motion. Maintenance, complaint on oath, and when we need an order of interim maintenance in the interim, you would also seek it arising out of the main application for maintenance. Keep it that way. Manuel, how can a Ugandan adopt a child who is not a Ugandan, say a refugee? High Court, because one of the parties is not Ugandan. Why vary the custody order under Section 130 and not revoke it under Section 116? Are you going to file an application for revocation, then file another application for variation? These orders were issued in one and the same order. When you ask in the first place, the order be varied in the following terms. Custody, the order which granted custody to the respondent be set aside. Aren't you thereby varying this order? That is a variation. You're not going to seek an application to set aside custody, then seek another application to set aside the order of maintenance. You know, in one application brought by notice of motion, you can achieve all that. This is one order granting different orders, directions. So in one and the same application, you can seek the order to be set aside, then the applicant to be granted custody instead, and maintenance to be set aside because the other person, custody has been granted to the applicant. Now, the issues I am taking you for granted. Didn't you read the Advocates Act? Didn't you read the Advocates Professional Conduct Regulations? Didn't you read the Advocates Students Practice Regulations? Don't you know that under those Students Practice Regulations, there are matters you have the mandate to handle as students and others not? You cannot apply for inter-country adoption, but you can apply for an order of custody or maintenance. If you have read the Advocates Act, don't you know the duties of an advocate to a client? Can you work for a client who has not given you instructions? What about negligence? What about confidentiality? What about overbilling your clients? What about negligence in the way you handle your case? Have you done research adequately? Have you drawn a competent application? If you lose some of these cases, it will amount to negligence because there are certain minimum standards expected of an advocate. And if you don't keep time and a client's case is dismissed for want of prosecution, have you acted professionally? For some of these things, I took you for granted. Donald Bareva, we are not dealing with the criminal law in this week. We are looking at civil remedies for ensuring the safety of this child. Pursuing the criminal offense in respect of Dombe would not give us the welfare we are looking for this child. Sharon Mudondo, you did not pay attention when I was reading the variation, the terms of the variation. It must be revoked and then you seek custody to be granted to the applicant. I think council, you'll be giving PAs a guide because we do different things and we, David Mogisa, we have a pre-teaching meeting every week, every subject before we come to class. What different things did you get? May I know? Don't name the PAs, but you can type so that we iron it out. You were taught by magistrates. These are the magistrates who preside over this code. We are taught by practicing lawyers who make these applications. When do we invoke section 1 on revocation? Your facts are very important. Now, I'm looking at these facts. I have a court order which issued of 3 directions. I can accomplish everything by having the order revoked and custody granted to another party and maintenance to another party. Supposing that the facts were different, that is why we always ask you to identify the material facts. So, Yoweri Peter Mwanje, if the facts were different and the order were only on custody, I would then pursue revocation. What happens when a child adopted the consent of the parent and then the parent finds that one of them turned gay? This would not be in the best interest of the child. This order can be set aside as you saw. There's a provision providing for setting aside adoption orders. In Uganda, we do not embrace homosexuality. It's a criminal offense. It will not give our children the moral value system we believe in. So that order can be set aside or revoked. The Children Act is silent on testamentary guardianship. The Succession Act provides for this. There's a clear provision. It was made, it was widened by the amendment of 2022. Can I seek both legal guardianship for dealing with property and also the other order in the same application? Yes. Yes, you can. Do we start whether or even what is markable? I haven't understood Gerard Munyanga. We have many questions but cannot able to get through. You see, if we ask people to speak, we will take a lot of time. But when we type in the chat box, that is for you, Wanyonyi. Now, Nambasa, in real life, you would also pursue the law on anti-homosexuality. But in this case, we are dealing with the remedies for this child under the Children Act. That is the purview of family law practice. In real life, all those remedies would be pursued. But imprisoning the offender would not give us any remedy for the children. So, in family law practice, we look at the remedies provided for under the Children Act and related laws. Mugerwa Arthur Caleb, issue on interim custody application. Section 1 of the Children Act gives the meaning of custody to include interim custody. Wouldn't that qualify its application to be the same? No, Mugerwa, no. This is custody, what it means, being in physical control of the child, even when you are granted a custody, pending the hearing and determination of a substantive application for custody, you would still be in custody. For that period which court has defined, the child may be taken away from you when, on determining the main application, court does not find you fit and proper. But for the 3 months in which you are with the child, pending the determination of the main application, that would be interim custody, it would still be custody. When you look at 116 on custody and Rule 19, 1J, do you see anything on interim custody, which 117 provides for? Do you see any procedure under 117? That is why we invoke Section 98 and Order 52, Rules 1 and 3. Counsel, is it mandatory to proceed by notes of motion under interim custody? What if I file an application not by notes of motion? So, Aruho, what application do you envisage to file if it is not a notes of motion in the matter of interim custody? Do you want to proceed by Form 1 for interim custody? Yet Form 1, Rule 19, 1J does not envisage interim custody. You have to know the law in and out. What are the contents of the custody agreement? You must know the law of contract and know the features of a valid contract. Then you look at an agreement between parties, the mother and the father. What would you agree upon? Don't you have parties? Don't you have the subject matter, the child, properly described and identified? This is a matter for the welfare of a child. Don't you envisage agreeing on who will be in custody? This is a custody agreement. If it is the mother who is in custody, what will happen to the other parent who has the right to know his child and whose child has the right to know the other parent? Won't you provide for access? What about maintenance? You people, you've got to know the law, then to think in a practical way. A practical way. If it is a custody agreement, definitely it concerns custody of this child. In terms of very vague, I haven't understood that. Whether court is authentic, verifying whether the court order is authentic, the Register of Titles writes to court, yes. You will also go there physically and study that file. It is not enough to write. You will go to court if you are a lawyer, registrar of titles, and ask for that court file and study it. You will not depend on somebody's letter if you are careful. The remedy of applying for legal guardianship still confuses me. I thought biological parents already. Please help me understand. Vicky, parents are the natural guardians of their children. I entirely agree. But a child has the right to own property. In week 1, you dealt with the position that a child can own a land and be registered as proprietor. And if you are the registered proprietor, you are the only person who can transact in that land because you have legal title. But children under the Contracts Act have no capacity to contract, as you know from year 1 at university, your law of contract. Now, if you are the biological parent, you have no right to sell or mortgage or give away your child's property, even if you are the one who bought that land for him and registered it in his name. He is the legal owner. He has the title. If you read some textbooks, you would understand this. Now, people who are not lawyers think that parents have the right to do this, but a lawyer who knows the law, that is why you are a lawyer, knows that it is not possible to deal in this child's property because he's the legal owner. Okay? That is why you need a legal guardianship order authorizing you in particular to deal with this child's property in a particular manner, which the order must name. I think I was very careful mentioning all these aspects. You must start on the premise that a child can own property, but he has no capacity in law to deal with it. He can't enter into valid contracts. And mortgaging this land, as in our facts, does not fall within the exceptions to the rule that an infant cannot enter into valid contracts. I want you to think like a lawyer, Vicky. A mother or biological father will only have capacity to deal in his child's property, even if you gave it to him, if you have a court order authorizing you to deal with it. And the court order must specify the manner in which you must deal with that property. So Vicky, if you took that certificate of title to the bank and told the manager loans that you intend to mortgage that as security, it would be rejected because the owners are you, Gabriel Akik, an adult, and the children. So it means only you, Gabriel, and the children must sign the mortgage contract. Yet the children are children in law, they cannot contract. You have to read some textbooks. The National Children Authority does not exist anymore. We have a department concerned with children in the Ministry of Gender. That is where you will register the order. Originally, yes. Now, no more. Section 130, student has asked. 116 is on custody of children. The court may at any time revoke the order of custody. 130 is on revocation, 130 is on a variation of a maintenance order. Oh, lawyers, I do realize that from the facts given, You can also seek revocation of this order, because we want custody to be changed from the mother to the father, maintenance to be set aside. So the students who have been arguing about revocation are right. You can seek revocation of this order. Now, under 130, supposing, let me explain by way of example. Supposing that in the facts, we had different facts. Father had been ordered to pay 6 million shillings into court and has been involved in an accident, and he can no longer pay, but he can only pay 1 million. Then in that case, you would seek variation so that the maintenance obligation is reduced from 6 million to 1 million. Yes, I now see your point of view, and I apologize. You are right on revocation of our order, because the remedy is to set aside custody to the mother, to grant custody to the father, and to set aside maintenance. You do not have to bring a separate application under 1162 for revocation of custody and to grant custody to the father, and a separate application for revocation of maintenance. You bring one application, notice of motion, seeking revocation of the custody order under 116 subsection 2, and further that custody instead be granted to the applicant biological father. Then thirdly, an order setting aside the order of maintenance. I apologize, lawyers, and I do say that the students who have been crying about revocation are right. You are right. I apologize for that position that I had gone wrong about in view of the facts. I do apologize. I think now you are happy. I do agree with you. Those ones who have been saying it is a revocation under 1162, given the fact. I also hope that with the example I have juxtaposed with our task, you can see variation under 130. When we seek maintenance to be reduced from 6 million to 1 million, because the person who was ordered to pay maintenance has been incapacitated. I am sorry, I apologize once again. Thank you very much for insisting. You have brought me back to the facts of the task. Aine Mbabazi, your lawyer guided that it is actually revocation. Yes. Aine Mbabazi, yes, I have apologized for my error. I have apologized. The PAs were right. I am the one who has misled you just now, and I apologize for that. What are some of the contents we put in the guardianship agreement? You mean remedy number 1 that we started with? It is the same. The first ADR remedy we have, appointing a guardian by agreement of the biological parents. You're looking at a contract, but this is a contract appointing a guardian of these children. This agreement can only be reached by the parents of the child. So definitely we want to see in the title, the laws under which you're proceeding, we want to see that this is a contract appointing a guardian of a child. Flower, Cascano aged this, a girl aged this. We want to see the parties properly described and identified, addresses, email, names. We want to see the description of the child because she is the subject matter of this agreement. We want to read about the parties' agreement on appointment of a guardian, who the guardian they have appointed is, name, age, sex, address, contacts, email, place of residence. We want to see when custody takes place. the guardian taking over the child. We want to see the obligations of the parents. These parents are living. Who of them is going to provide for maintenance of this child? Access, duration, dispute resolution, because disputes are bound to arise. We want to see other aspects of a contract. We want to see that the parties have intention to enter into this contract, that it is free of morbid vitiating factors like duress. You know, that is at the very beginning in your preamble. Then the witnesses who are supposed to, the section requires probation and social welfare officer, then that official of the area, local council. If those ones are not the witnesses, it will be void. So you are supposed to apply that section on appointing a guardian by agreement, together with the welfare principle, together with the duties of parents to children under the Constitution and under the Children Act, and your knowledge of the principles of law on a valid contract, the features of a valid contract, to come up with further information. And that is the information that translates into the substance or contents of this kind of agreement. So we see how we apply the law to practical situations. And you are going to draft all these documents in the oral examinations orally. So get serious in case you are still sinning. Ngobi. The guardianship by agreement, and she said custody. Really? Ngobi, you probably meant section 76, not 77. You said our PA, the remedy of a guardianship by agreement was raised. You raised it and your teacher disagreed. She said it is interim custody. Ngobi, I believe you are talking about task A in workshop number 1, that ADR remedy. Interim custody cannot work. Interim custody would be one of the parents. Father has molested this child threatens to take poison. She must be removed from this situation. Mother leaving tomorrow for United Arab Emirates. How can interim custody work? Because you have to seek an order of interim custody from the Family and Children Court. Do you think it can sit in a matter of hours to give you that order? And is the mother going back to UAE with the child? No. The facts are that they have a great bond with grandmother. Father has molested, child not willing to live here, and any parent would know that child is not safe. She will be sexually abused by father, physically and emotionally abused by house girl. And so we are looking at 77. Now, 77, joint guardianship. Court may appoint more persons to act as joint guardians. That one would also not help us because court, we cannot get a remedy from court in a matter of hours. In our facts, she's leaving tomorrow, looking at that date, because we learned on 17th, the facts stated that she would leave for UAE on 18th. So there's no way you'll get an order from court under 77 in a matter of hours. Lawyers, that is where we go wrong when we don't understand the facts. So Ngobi, interim custody certainly does not apply because it is a court remedy, which we seek by making a formal application, as we have already seen. Then the parties must be heard, inter-parties, both parents, submissions, court writing a ruling. It will not happen in 1 hour or hours or a day or 1 week, but she's leaving tomorrow. So we could only zero down on 76, appointing a guardian by agreement. Oh, lawyers, I must thank you so much. I thank you for having insisted on showing me revocation on 1162 and the difference between 130. Thank you very much. You brought me on course. I had erred. I apologize. I apologize. But in the same breath, I hope that we have seen variation of a court order, how they compare. But I am aware that you already know. That is why you have been insisting on the right remedy under 116. I know you know. So lawyers, I don't see any more questions in the chat. Yeah, 99. I have not read about constructive fostering under the rules. Nzalibara Hashim, I have not. Where do we go? Lawyers, I realize that it is 4 p.m. and your teacher must be ready to introduce the week's work. I would like to thank you. I continue to thank you for having brought me back to revocation. I would like to thank you so much. And I know you still have questions. This is what I would like us to do. We are a team of many PAs. By now, you have identified the teacher who helps you to understand best. Continue sharing your questions with them on email. They will answer your questions. You can also call. They will answer your questions. You can send questions anytime, anytime. When we wake up at midnight or 4 a.m. and we see them, we answer. I would like to thank you very, very much.
Good afternoon, students. I don't know whether you are able to hear me.
Sir,
Can I be heard?
we can hear you, sir.
Yes.
Yes. Good afternoon, students. I'm sorry, I didn't know that I was already scheduled for this. You know, we have been teaching on the first intake. Now we are supposed to take you on for the second intake. We had even a guest speaker now. There's follow-up this side. There's introduction on this side. So I'm sorry for a mishap. I hope I am the one taking you through. We are going to, in the coming week, we are having the process subsequent to institution of suits. We want to see the processes that involve service of summons, filing defenses and replies, instances where you make the several applications under Order 9, where there's default judgment, interlocutory judgment, and ex parte judgments, and the processes of setting aside those proceedings. I have sent you workshops now. You will get time to read them and appreciate them. However, we are also taking on the process of closure and dealing with things to do with summons for directions when the pleadings have been uh, when the pleadings have been concluded. Summons for directions, by then there are processes to do with things like witness statements, filing, scheduling conference and memorandum, and trial bundles. And then we are able to see whether or not it's appropriate for summons for directions and the subsequent orders that we need before the hearing. Then there's a process of scheduling when you go before the court to make a scheduling, but of course now it has been overtaken by having scheduling memoranda jointly executed. But the presumption is that scheduling is supposed to help you sort out matters of agreement and matters of disagreement. So we need to see in these coming workshops that if, for example, they have served you with a pleading, what are we supposed to do? Supposing time has expired, supposing you have not filed the defense in time, what do you need to do? Supposing you want to make amendments, supposing you had not served in time, what do you do? All these are aspects we are going to deal with. If you don't file a defense and the other party takes action, what can you do? Under what circumstance can we set aside those proceedings, both under Order 912 and 927? These are the aspects you're going to deal with, and they actually encompass the whole process of the hearing. From the time of closure of pleadings and all these other aspects that are in the process of us making sure everything is okay, to the process of us taking out in terms of taking out witness statements and their content, and also seeing summons for directions, which are a management tool on how proceedings will be managed, scheduling, which sort out matters of agreement and disagreement, and then the case can be ready for trial. That is basically what you're going to discuss in this week. It's a fairly clear week with interesting arguments that are very important. I don't expect you to have more complications in it. That's basically what we are going to discuss. I have sent the workshops on your group. We shall interact with each other. I know you are online, but please take these online classes very seriously. I know some of you think they are a joke, but please, you do it at your risk. Basically, that's what I was meant to do. I don't expect many questions because those questions will be resolved in the course of the week. I beg to end my presentation here. I thank you.